Good morning, everybody. I'm Rudy Rodriguez, and so glad to welcome you all to our next CLE session, which is Top 10 Ethics Concerns for In-House Counsel. We're grateful to our sponsor, Greenberg, Traurig, for their continued support of our chapter, especially in light of all of the craziness of this year. So I'll introduce our speaker today, who is Jordan Kalman. Jordan co-chairs the firm Greenberg Traurig's Labor and Employment Practice, International Employment, Immigration, and Workforce Strategies Group. He's a longtime U.S. business representative to the United States International Labor Organization in Geneva, Switzerland. He's sought after by businesses when issues arise concerning international and cross-border employment matters, corporate social responsibility, international corporate campaigns, and other international labor and employment matters. Jordan is also sought after by clients around the world for insight on their worldwide operations, and direction on matters related to managing a global workforce. He handles many types of employment matters, including discrimination, wrongful termination, wage and hour compliance, labor arbitrations, trade secret and non-competition cases, and also internal corporate investigations. He also counsels employers concerning day-to-day human resources issues and all kinds of legal requirements in the workplace, particularly related to significant operational changes such as mergers, acquisitions, business relocations, and reductions in force. So obviously Jordan has his hands full. We appreciate your time today, Jordan. Take it away.
Thank you so much, Rudy. The audience that's remote can't hear the thunderous applause I just got. It was unbelievable. Okay, so if you all have not read that article that recently came out in Texas Law Books on Rudy, it's unbelievable. I think you all should read that article. Check it out, Texas Law Books. I think Mark Curidan was he the author, Rudy? It's an excellent article. I commend it to you. So let's talk ethics. And I know that you all are sitting there, and probably some of you, maybe a couple, are here just because you need ethics credit. All right, so I get that. And so you're thinking, oh, here comes another ethics presentation. It's going to be like watching paint dry, right? Well, let me just make a little representation to you. Let me just make this representation. This is a riveting presentation. Riveting, all right? So listen up. Hopefully I'll tell you something you don't know. But in any event, let's have fun. It's so nice to be around people again. Really it is. So here's what I want to do. I want to bring these ethics issues to life for you so that you understand what those ethical rules are, recognize these issues, and also act by properly responding to the ethical issues and exercising due professional care. That's what you're here to do. Learn about ethics. You want to be able to represent your client with confidence, right? That's all of our goal. And I can tell you, as we go through these scenarios and through these top 10 issues, there really is not a simple, easy playbook. You've heard the saying that says, for every complex issue, there is a very simple solution, and is usually wrong, okay? That's what you need to understand, and you need to have trusted advisors, people you know you can go to run these ethical issues by. So first, let's talk a little bit about privilege. Okay, I've done a lot of work in the privilege area. I'm on the Sedona Conference drafting committee for the cross-border attorney-client privilege. So I'm fairly knowledgeable about how these issues work. Well, ask yourself, who wants your privileged information? All right, so I know some of you in the audience, but I don't know all of you, but certainly I can tell you your competitors want your privileged information, don't they? Opposing litigants, investigators, regulators, right? The government wants your stuff. Well, raise your hand if you advise your client on compliance, right? Everybody does. Everybody should have their hands up because everyone in this room is advising their client on compliance. Well, here's my question to you and your legal department, okay? Are you in compliance? What about you? Look in the mirror. Who is supposed to be protecting your client's privileged information? The treasure trove of secrets of your company. That would be you, okay? That would be you. Put your business card here. So first, let's take a look at the perils of traveling. So all of us have traveled, all of us have been to an airport, probably all of us have been outside the United States, right? What's the big deal? What's the big deal? Well, let's just imagine, come on an imaginary journey with me, imaginary journey. And imagine that you and your client, you've got this Anti-Money Laundering and Foreign Corrupt Practices Act, and Canada's open, for us to go to. So all of a sudden here, you're going to be going to Vancouver. You think maybe you'll get a little skiing in at Whistler and have fun, right? It's a grand adventure. Glad to get back on the plane after so many months of not being on. So you're going to be going to do a little investigation, and you're going with your client who you want to impress, right? So what do? Well, what happens, the way you get this assignment is you're sitting right here in this room, and you start getting emails. And you know how dadgum rude it is to be checking your emails and looking at your iPhone while someone's speaking, right? And so nobody is doing that, but this thing keeps buzzing, and you think, all right. What is it? Well, guess who it is? It's your boss and your boss's boss. And they say, you're a superstar in the legal department. You're the one we want to do this investigation. And you're like, me? Anti-Money Laundering, Foreign Corrupt Practices Act? Okay, yeah. I'm so flattered that they chose me. They chose you. So now you want to impress everyone. So what you do is you start preparing. You prepare like you've never prepared, because you are going to write the memo that brings a tear to their eye. That's the most beautiful legal prose I've ever seen. That is unbelievable. Okay? That's what you're going to impress them. You're going to knock their socks off. So your assignment is to investigate, to interview witnesses, and then to opine. And so what you do is you start studying the issues. Start studying the government's enforcement agenda, which is so important, right? Where is the government looking? What are they looking for? You look for strategies, weaknesses, you got diagrams, flow charts, tons of privileged information. And you start looking at it, and things don't look good. Things do not look good on FCPA, Foreign Corrupt Practices Act, or Anti-Money Laundering. It's looking pretty bad. And so now you're going to go traveling, right, to Vancouver. And so you don't want to take a bunch of boxes with you, so you digitize everything, put everything on your thumb drive, your laptop, your smartphone. You're traveling light. You're kind of a cool traveler. Don't want to check a bag even, right? So there you go, traveling light. Well, fun and adventure await, right? I mean, now you're revved up, you're ready to go. Well, you land in Vancouver, and what do? First, you go through immigration, right? Welcome to Canada, thank you, with your passport. Then you go to collect that bag, okay? And you got nothing to declare, right? You're going to go through customs. What do you have to declare? So you're walking through with your rolling bag, and all of a sudden, that Canadian customs agent snaps his fingers like this. You. You're like, me? Yes, you, come over here. What, yeah? What have you got there with you? I've got my smartphone, I've got my laptop, I've got my thumb drives. Really? Give those to me. Whoa. I am not giving you anything, because this is all chock full of attorney-client privileged information. Really? Well, let me just put a real fine point on this. Either give it to me, or we're going to refuse you entrance into the country, and and maybe we'll arrest you. Well, someone like Rudy would take one for the team, right? I mean, he's okay, right? But the thing is, most of us would say, okay, here it is. And once you give it to them, it's in the public domain. And then the question is it discoverable? Well, let's just say none of that happens. Let's say that it goes swimmingly well, and you are ready to rock and knock the socks off your client. Home sweet home. So now you're coming back, and you're coming back to DFW Airport. Think how many times you've been there, right? You're a DFW, you know, stamp your passport, welcome home. Thank you, it's good to be home. Loved Canada, glad to be home. You know, and on the plane back, you're working on your memo, you got everything done, and so now you go to collect your bag, and the customs agent snaps fingers at you. You, me? Yes, you. Come over here. I've got nothing to declare. Yeah, well, what have you got with you? My thumb drive, my laptop, my smartphone. Really, give that to me. Now you're at DFW, okay? You're at your home turf. No, no, no. Nothing is going to you. I am a big shot lawyer. You are not getting a thing from me. Step aside. I'm heading home. Well, big shot lawyer, maybe you've heard of some of these things. You know, like the border search exception to the Fourth Amendment. What? I don't think I studied that in law school. Yeah, that says that a sovereign nation, not only the United States, not only Canada, but any nation, right? Fourth Amendment says this sovereign, the United States of America, can inspect anything that comes into this country. That is a thing, and we are going to inspect it. So give it up. And so the stuff that you take over to Canada and back, it's like a locked suitcase. And what's the key? Come on, what's the key? That's right, your password, right? Your password is the key. So give me that password. And so the thing is, you're thinking, well, I've never seen that happen before. Well, it has happened at DFW Airport. It's happened at Boston's Logan Airport. It happens at LAX. It happens at JFK. It happens more and more frequently. I just pulled some headlines and threw them up on this slide. So here, you are subject to a suspicionless strip search. Once you give it up, it's now in the public domain. And you know, the thing is that there are some limits, okay? And the limits are that if Customs is going to inspect this stuff, because perhaps the Department of Justice or the FBI has called and said, I want what's on this lawyer's laptop, thumb drive, and smartphone, and they sick the immigration and customs folks on you, and then all of a sudden this is there, they can't take your stuff and keep it for months. They have to inspect it, just like they're going through your bag, right? Just like a common inspection. There are some limits on that, and that's what those are the two cases I've cited. So you're thinking, but I've never seen this. This is ridiculous, you know? Really? It's a red hot issue. It's a red hot issue. Tons of legislation being introduced. Well, tons may be an exaggeration. Legislation has been introduced to place restrictions on the border search exception and what Customs can do when something comes into the country. And so we know that we're bound by ethical rules, right? And part of what the ABA says is, you know, don't take stuff with you if you don't have to. If you do take stuff with you, you know, perhaps consider taking new equipment with you as opposed to all this stuff. Some of my clients travel with laptops that have the keys to the kingdom on them, right? You know, 15 years of records, and they're going to India and all around the world, taking this, putting it in jeopardy every time they cross borders. And so the ABA says it's a big problem. They issue guidance for all of us, and they say, you know, consider taking a burner phone. They don't take a burner phone, but you know, those of us who've watched Breaking Bad, we just can't resist, right? So a burner phone, take brand new equipment. Why brand new equipment? That doesn't completely get you out of the woods, but we can tell you that if you're not taking a lot of stuff with you, you have a lot less stuff to lose. So keep that in mind. Anyway, the Model Rule 1.6 says, a lawyer shall not reveal information protected by the attorney-client privilege under applicable law. Okay, I highlighted that word applicable. I don't know if that's the way you pronounce it. Is it applicable or applicable? I'll just say applicable. It sounds more sophisticated. So applicable law. So then you might ask yourself, now which law applies here, right? Which law apply? What law am I going under here? Am I going under Canadian law, Texas law, Oklahoma, Pennsylvania? Where am I? What law am I going under? So, you know, there are every state has different laws. Every country has different laws. It's not surprising. And our natural inclination is to say what happens here happens in another state or happens in another country. It's just not the case. So anyway, travel, the perils of travel. Number 9, dual roles as serving on a board of directors. So you've got dual roles. And the question is, does attorney-client privilege attach to communications at a board meeting? We all know the way this really works, right? Don't we? They invite a lawyer to a meeting, they meaning the board, they meaning the business folks, or they copy you on an email, and they automatically think, they get giddy because they think it's all privileged just because you're there, you're in the room. So here, what role are you serving? Are you there as a lawyer? Which hat are you wearing? Perhaps more importantly, what hat do they think you are wearing? They think you're there, they think it's privileged. Well, your job is to let them know it ain't privileged, right? Your client needs to know when something's privileged and when something's not privileged. And if you're invited to the meeting, and because you're invited to the meeting, they think it's privileged, that is your job to dispel that. And that's why going through training and protocols and making sure that your client knows whether something's privileged or not is very important. Conflicts of interest with current clients. Okay, you can't represent a client if that representation involves a concurrent conflict of interest. And there's a significant, up there on the screen, there is significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibility to another client, a former client, or a third person, or by a personal interest of the lawyer. And so here, and this is something I want to emphasize very much, number 8, the client-lawyer relationship. So here, read this rule, 1.6. It says, a lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent. Now, where in that does that say privileged information? It doesn't say privileged information, does it? It says information. So this is called the no gossip rule. So that means you're not supposed to be talking about who you represent. Okay, obviously it may be quite obvious who you represent, but you're not supposed to be talking about who you represent. You're not supposed to be gossiping about your client unless the client gives you permission. That's the no gossip rule. And so folding onto the no gossip rule is metadata, cloud computing, practical stuff. So some states, you are ethically required to take reasonable care to prevent disclosure of privileged information, right? True really in just about every state. And that includes metadata. I mean, we've heard those horror stories, right? About sending a document out where you haven't removed the metadata and your opposing counsel or whoever you don't want, whoever is not your client, can grab that up and reveal what has been changed. And probably now most of us have these automatic cleaning things before you send something out, and you can suspend that if you need to. Well, you need to be very careful about that, and you don't want to reveal that confidential information. Know your client's software, right? This is your job as in-house counsel, to know your client's software and the benefits and risks of storing things in the cloud. Because like when you're traveling overseas, I know what I'll do. I'll just put it all in the cloud. I'll just put it all in the cloud. But what happens when that snapping fingers customs agent says, give me your password, and then says, can you tie back into the US server? Seriously? Let's go ahead and do that. Whoa, whoa, whoa. Or maybe if that happens, you call back to headquarters and say, hey, suspend my account quickly. Can you spell obstruction of justice, right? So we just want to be careful. And you need to see around corners. That's part of my message here is we need to be proactive in anticipating these ethical questions and then dealing with them, as opposed to waiting till the toothpaste is out of the tube and then trying to put it back, okay? So anticipating those issues to see around corners. Number 7, you can't make false statements. Dishonesty, the rules talk about dishonesty, fraud, deceit, misrepresentation, and dealing with those not represented by counsel. How many times have any of us been involved with a deal and you're very comfortable? You know the people on the other side, and you know the lawyer on the other side, and the lawyer who you're dealing with on the other side is busy. And you know the business people, right? And it's kind of chummy, kind of informal. And then you start talking with the business people without the lawyer being present, okay? That's a big no-no. You can't do that. They're represented by counsel. You can only speak and communicate through counsel. So you can't do that. And dealing with those not represented by counsel, your only advice to them is get counsel, please get counsel, right? I'm not your lawyer. I am not your lawyer. So on that same note, engaging third parties. So lawyer is supervisor. Think how many audits you supervise or that you know are being supervised. They're privileged audits. And so what you think is, or what your client thinks, certainly not you, certainly you don't think this, but your client thinks if the lawyers order up the audit, it's privileged, right? Well, the thing is, it's not a set it and forget it thing, because the courts say, you know what? If you're doing a privileged audit, it's not a set it and forget it. Hey, go ahead and do that audit. This is all under my supervision, right? Well, what the courts require is that you have meaningful involvement. You can't just tell them to do it and then come back with the work product. You have to be involved and show the court, demonstrate to the court, if it's ever challenged, that you are indeed meaningfully involved. And work product doctrine. Okay, when is litigation anticipated? All right, so you think, well, think if that was a law school exam question. When is litigation anticipated? And you think of all the paragraphs and all the great legal prose you would write. Well, you know what I say? I mean, come on. Litigation's anticipated when what goes out? Yeah, litigation hold, right? You send that lit hold out and pretty soon there's no ambiguity. It's like, yeah, litigation's anticipated. When you look and see attorney-client privileged information, you know, some of y'all may be familiar with the recent Baylor case. And I know I'm butchering the facts. Let me just give you the 10,000-foot view. There are real problems at Baylor. The board starts an investigation. They hire a fancy law firm to do this investigation. Fancy law firm produces a report to Baylor. All the alums are dying to know what happened at Baylor, right? So they're pressuring the board, what happened? And so the board sort of tunes up outside counsel's report and sends it out. And then bad things happen, okay? Bad things happen. And basically, the court starts looking at this saying, hey, you've got a big waiver problem on your hands, a big waiver problem on your hands. And so, one of the things to consider, and I know I keep harping on these audits, but I see that as a big problem, and that is to have those audits done by outside counsel. That's good. Have protocols and training in place for those receiving those audits, and then understand what the scope of the audit is and the purpose of the audit. Very, very important. So more on the Baylor case. I'll just read that. I know it's a little bit small. It says, the privilege, this is from the case from 2020. The privilege-related losses keep piling up for Baylor University and its defense against Title IX claims. 3 years after suffering a sweeping attorney-client privilege loss, the federal court ruled that Baylor waived its work product objections over its outside counsel's internal investigation materials, okay? So we're talking about work product, okay? We're talking about work product, witness interviews, emails between the lawyer and the client, electronic, search, discovery terms, all that stuff was waived. So what do we know? What lesson can we learn? Broad communication can waive privilege. The attorney-client privilege is only between an attorney and a client, and I'll get into that definition in just a second. But a party waives work product doctrine. This is the shield and the sword, right? A party waives work product doctrine when it asserts a claim or defense that relies on work product to prove its intent, its knowledge of the law, or the reasonableness of its conduct. What Baylor is proposing is that it be permitted to explicitly rely on the work and advice of outside law firm, I redacted the name, while leaving the law firm branding off the work, right? Take the law firm's name off, send it out. Let's don't do that. So that's another very important thing. And how, do I have a timekeeper in here? I want to make sure I'm staying on. Oh. No, that's okay, Rudy. Tell me what time it is. I want to make sure I stay on. 10:42. So I have until 11? Okay, all right. So defending depositions, what's the big deal, right? Well, guess what? Defending depositions, an appearance at trial or a deposition by counsel not admitted in the relevant jurisdiction, and we've actually seen this happen before, most likely is the unauthorized practice of law. So let's just say you go to a deposition out of state where you're not licensed, and you're with your trusted local counsel, and you're at a deposition, and you decide to pipe up, wait a minute, or you object or something. Well, when you appear, you make an appearance, that can be the unauthorized practice of law, and the unauthorized practice of law can be a misdemeanor, like criminal stuff. And in-house counsel who are not admitted to practice should be admitted, pro hoc vice, prior to the time of any appearance at trial or deposition. And we had that happen with a client who spoke up in court when they were not licensed, and it caused a big problem, okay? It caused a big problem. Number 5, are you rendering business advice or legal advice? So simple, come on, seriously? We know what legal advice is, we know what business advice is. Could that really make the top 10? Well, let's look at this press release from Siemens. It basically says, look, the new worldwide counsel, their responsibilities go far beyond merely identifying risks. Okay, you call me, I'm outside counsel, Greenberg, Traurig, right? Outside counsel, when I give you a memo, give you advice, it's presumed to be legal advice. When you as in-house counsel start giving advice, it's questioned because you're an integral part of the legal team, just like the Siemens press release, right? You're an integral part. And so you have to be very clear on that. So with respect to business and legal advice, anything that's not legal, right, is business. A corporation can't insulate itself from discovery simply by copying in-house counsel. That kind of goes back, right? You're copying on all these emails. Everybody thinks it's privileged. Well, that's not right. Sitting in on meetings, you can't sit there and be a potted plant and suddenly, I hate to use this word, but privilegize the meeting, right? You can't do that. That's not how it is. And so why is that the case? Well, let's look at defining attorney-client privilege. It's different under every state may have a different rule, and certainly every country does. But basically, it's the confidentiality of all forms of communication between a lawyer, easy, right, and a client, easy, right? This is like playing chopstick on the piano for us, right? A lawyer and a client, got that, for the purpose of the attorney rendering legal advice. Easy. Except when they second guess the communications you've had because you have a title that says general counsel and chief compliance officer, or associate general counsel and VP of whatever. Now you have a dual role. And so the question comes up, well, what is your role? You have 2 titles down there on your business card and on the little footer on your email. So, better when you're rendering legal advice to be able to say, this is clearly legal advice, I'm only using my legal title. Wouldn't it be magical? Wouldn't it be magical if your client sent this to you, right? Hello, lawyer. We hereby request legal advice on the following. Okay, wouldn't that be just like morning in Reagan's America, right? The birds are singing, the sun is shining, it's a cool spring day, right? Wouldn't that be great? Wouldn't it be equally great even if you didn't get this, if you wrote something like this? Hello, client. In response to your legal advice, we say this. Wouldn't that be great? In other words, hey, everybody, I'm fixing to dispense some legal advice here, right? It's like, cool, right? No question. So then client, who is your client again? Is it the parent, the subsidiary, the shareholder, direct officers, board? And which test? Remember the subject matter test? That's the broad one, right? In other words, if you're talking to some of your employees or the board or whoever about the subject matter, that's privileged. Well, that's not the way it is in all courts, in all states. Sometimes there's the control group, which can be a narrower group of people, right? People with authority to act on legal advice. So which test are you going under? Who's your client? Something that you need to ask yourself. So here's a key point. Identical information receives different privilege status in different jurisdictions. Okay, what? What am I talking about? Seriously? You mean like what's privileged here is not privileged there? What are you, what now? A document created in one jurisdiction may not be where an arbitrator or court will decide whether the document is privileged or discoverable. Well, shoot, I thought I only had to worry about Texas, right? But you mean some other court somewhere else is going to be determining whether this is privileged? Surely they'll apply our law, so we got nothing to worry about. But what you'll find is when you get outside the United States, kind of like that cross-border travel example, is that things don't quite work the way they work here. Something's lost in translation. Perfect example, I go to Banff, the Banff Hotel in Canada, and I go to a party there, a big party. So they got this great band, great live band. And so the band starts off and the Canadian band gets up there and the lead singer says, "We're gonna kick off this set with a little ZZ Top." Okay, and so the crowd just roars, right? And I'm sitting there going, ZZ Top? Like I've never heard this before. So some things can be lost in translation sometimes. Let's take a look. The RBS case, Royal Bank of Scotland. Okay, here, the Royal Bank of Scotland investors, they suffer a loss. These investors suffer a loss and they sue in London. Okay, easy facts. RBS receives discovery requests for RBS's US and UK outside counsel notes. Please send us your outside counsel notes, okay? And they're seeking notes from interviews that their outside counsel did with employees in the US and the UK. Well, objection, that's easy, we got this. This is work product. So, hello, London court, apply the US law where the jurisdiction where the engagement was made, the instructions were made, and that's what, certainly you're not getting US, I don't know about the crazy UK, but, and US law applies, and we know that US law under federal law, the Upjohn case, right? It's subject matter, broad, so we're cool. Problem is that the UK court is determining whether or not it's privileged or not. And the UK does not apply our law, rather they apply their law. Their law. And when they apply their law, lex fori, the law of the forum, privilege is more like the control group that we would call it. And privilege does not cover the stuff that we're objecting to. And we know that facts are never privileged, so guess what? It all comes in, okay? It's all produced. And suddenly you're thinking, so you mean something I do here could be interpreted by a UK court and it has to be produced. You have to be clairvoyant. In other words, where is this information going to be vulnerable, right? So identical information receives different privilege status in different jurisdictions. The law of the forum, are you creating discoverable documents, discoverable in other jurisdictions? You got to think ahead, develop your powers of clairvoyance. So what I say is slow down, don't assume privilege exists, think it through. Which test are you going to be under? Where is litigation likely to be brought? Which law applies? And we know that I say courts hate privilege. That's not exactly right. Courts say if you're going to have something privileged, you better dot every I and cross every T. It doesn't mean everything you need to go to huge Herculean, efforts to make everything privileged, but some things you do. And when you do, you need to be extra careful. So, you kind of go game theory on this stuff. And basically, I'm not going to go through this stuff, but basically you need to say, where is this information going to be requested? Where is the most likely place? And then you go through the analysis, right? You go through this complicated analysis to say, where is this stuff? What should we do? Should we have outside counsel look at it? Should we have outside counsel, engage outside counsel in that jurisdiction? And then what are the laws in that jurisdiction? Well, I gave y'all a laminated privilege card. I've got, if all of y'all didn't get one, there are some here. And for those people who are watching live, I guess we can figure out a way to get you one if you want one. You can email me or Susan Harvey or someone to get that information. But I have some extra copies up here if you didn't get one. So that tells what those laws are. In one column, I want to call your attention to is, let's see, it's the middle column, privilege for foreign licensed lawyers. In other words, if you go to this jurisdiction, is what you do privileged. So for example, if you flip over to the second side and you go to, let's see, Singapore, okay? Singapore says, if you go to Singapore, what you do there can be privileged. You see that green check mark? So if you have any questions on this as you go through it, feel free to give me a call. But it is hopefully a handy desk reference for you. So some things to establish and preserve privilege with experts, local counsel, and internal investigations. When this starts happening, I know this stuff seems routine. How many internal investigations have you done? This is old hat. You don't need any ethics schooling on this stuff. Well, let's take a quick step back. Sometimes having outside counsel retain local outside counsel and experts is a good thing. That doesn't completely get you out of the woods, but it does put a speed bump there, right? And also when you get work product from me or your outside counsel, and you think we pay these exorbitant legal rates, and all of a sudden we get this stuff and the lawyer didn't get the facts down and so on and so forth, and it's so disappointing. I've got to redo this memo, and I told the lawyer not to do this, and they did that. So you completely revamp the work product. Well, suddenly it becomes your work product, right? Suddenly it's not our work product, it's your work product, and that's further subject to scrutiny. We see our clients undertaking fewer internal investigations, and you have to have careful, thoughtful, and clairvoyant outside counsel. And I'm thinking Baylor, right? The Baylor, what is this report going to be used for? I think the Royal Bank of Scotland case, where can you anticipate litigation might arise? Things like that to consider. Number 3, client confusion. Internal investigations are replete with ethical issues. Okay, so these clients of yours, right? When they're talking with you, they think everything's privileged. I'm talking to a lawyer now. They think you're representing them individually. We know how this works in real life, okay? We know how that works in real life. Things are not so clear. And so we know that, if you are not representing them, you need to make that clear because they are relying on that. And a lot of their subjective belief is going to carry the day with a court or a trier of fact as to whether or not there is privilege and whether or not you breach your ethical duty. Email in haste, repent at leisure. That's borrowing from my grandmother who used to say, marry in haste, repent at leisure, okay? And she can speak to that, but in any event, mistakes can result in sloppiness. Look, things are moving fast. Come on, y'all. Things are not so clear. Things are moving fast. You don't have time to sit back, drink a cup of coffee, look out the window, contemplate some ethical issue. Things move fast, and we have to be careful because we're the lawyers. We have to have attention to detail. We can't get sloppy. Make sure that these people know who you're representing and who you're not representing. And be careful with what you put in writing especially. So this is who's your client? Remember, under which law? Well, we know that an organization can only work through its authorized representatives, right? And we know that there can be conflicts of interest. For example, if you're representing a director and the company, you can't do that if there is a conflict of interest. And if you do have a conflict of interest, generally speaking, it can be waived. But certainly, if you look at the bottom, certainly it can't be waived by, you can't get the person who you're going to be representing to waive the issue for the company, right? So the CEO says, hey, I want you to represent me individually in this, and you can't get that CEO to waive the conflict on behalf of the client. So litigation news. All right. The attorney-client privilege does not apply to former employees. This is such an interesting and complicated area, okay? Because you've got the subject matter control group, then you've got employees who are leaving, you have a lot of layoffs, and now people in litigation are going to be testifying. Well, what's privileged, what's not privileged? Well, we know from the Upjohn case, and if you haven't read the Upjohn case recently, just pull it. It's like one of the most famous cases ever from the US Supreme Court. Read that case and see about the subject matter test and what the court says. It rejects the control group test, but this is for federal law, right? Different states have different laws and different countries do too. The question in this case, the Upjohn case, gave no guidance for former employees, none. So we don't know, is it privileged or not privileged? We'll take a look at this case from Washington State Supreme Court. Everything changes when employment ends. Termination of employment ends the agency relationship. Former employee is a third party. They're a stranger. They're a stranger to the attorney-client privilege. But privileged communications during employment remain protected after employment terminates. So it's hermetically sealed, and then the person leaves, and then there's no more privilege. They're a stranger now because they're not part of the attorney-client privilege circle. Former employees, blanket attorney-client privilege assumptions are not advisable, okay? Think through the issues because we get in a hurry. Let's start calling those former employees, right? Let's start doing this, doing that. Former employees like, well, do you represent me? What, could I get in trouble here? They automatically assume that you're their lawyer and they know you so well, right? Real chummy, real informal, you get sloppy, and suddenly you start getting into real trouble. And remember the Upjohn warning, right? The Upjohn warning just says, hey, look, I represent the company. I don't represent you. And so, if you want to get your own lawyer, understand I'm not your lawyer. I'm the company's lawyer. That's basically what the Upjohn warning that you hear is all about, just letting them know. And be cautious on what you share, right? Because loose lips sink ships. And I can't tell you how many times we've seen this in our own observed experience. So let's be careful. So I know I need to leave time. Rudy, how much time do I have? 15? All right. So here is the most interesting thing, because I'm going to leave, because they told me to leave it at 10 minutes for questions, and I certainly will. If not, we can break early. But here is I think, one of the most fascinating things. And I think this is completely fascinating. All right. So here's the headline. How VW's in-house lawyers screwed up a litigation hold. How can you screw up a litigation hold? Think how many litigation holds you've sent out or have had your outside counsel send out, right? It's easy. You have this little form. It's so cool. It won't rust, bust, chip, crack, or peel. You're very proud of it. Like I say, it'll bring a tear to any lawyer's eyes. Mike, that's the best litigation hold I've ever seen, okay? Well, here's what happens in the Volkswagen case. You all may remember this. This is this emissions scandal, right? Where they were allegedly misrepresenting the amount of emissions that were coming out of their cars. So here's what happens. And I'm going to read this. This is from a National Law Journal article. I'm going to read it because I generally don't like reading things when I'm giving a talk, but this is really, really, really good. Okay, it says, The obstruction of justice charge filed against Volkswagen on Wednesday, this is from 2017, pertains not only to lies by the employees to federal regulators, but also to actions by VW's in-house legal team, according to statements attached to the plea agreement. The statements say VW's in-house attorneys tipped off employees about an oncoming litigation hold. And at least one in-house counsel apparently indicated to employees that they should destroy certain documents and a hard drive that pertained to VW's emissions cheating issues. Based on the statement of facts in the plea deal, under the section titled Obstruction of Justice, this much is known about the in-house legal role. In the summer of 2015, in-house counsel for Volkswagen America contacted Volkswagen Germany to alert them that their lawyers were preparing a lit hold related to the emissions issue. Hello, Germany. This is the United States calling. We're fixing to issue a litigation hold. Okay, that's what they say. In August of 2015, VW America's legal team sent the text of a not yet issued lit hold notice to Attorney A. Okay, don't be Attorney A. You do not want to be referred to as Attorney A. Okay, so on August 26, 2015, Volkswagen America's legal team sent the text of a not yet issued lit hold to Attorney A in VW Germany. Here's the text. Here's what it's going to look like. The next day, Attorney A met with several VW engineers to discuss the illegal admissions defeat device. They had a little device, that tuned up the emissions data. So the next day, Attorney A met with several VW engineers to disclose the illegal emissions defeat device at the heart of the scandals. The document says, Attorney A indicated that a hold was imminent and that these engineers should check their documents, which multiple participants understood to mean that they should delete documents prior to the hold being issued, it states. So kind of a wink, wink, hey, everybody needs to, carefully check those documents. So at the meeting on September 15th, Attorney A met with about 30 to 40 employees and indicated that emissions-related data should be kept on USB drives and put on the computer system only if necessary. Thousands of documents were deleted, but many were later recovered during the investigation. The entire cover-up finally fell apart in November 2015 when a VW employee admitted the entire thing to regulators. So, those are what I see as the top 10 issues. I think that I typed out that number one issue here because something as simple as an audit, okay? Make it a privileged audit, no problem, got it down, no worries, all supervised by me. Really? How involved are you? Well, litigation hold, give everyone a little heads up, maybe not. Maybe that's not a good idea, right? You see what happens in VW. When you travel, let's be careful what you take with you. Let's know what these laws are. You think the laws in England, England, the English laws, there are our great-great-grandfathers in law, right? Our law stems from England. The first item of most states except Louisiana says we hereby adopt the English common law. Every constitution says that, right? We all stem off the English common law. So of course their law's the same. It's not the same? What? Privilege? Royal Bank of Scotland case? So you can see how we have to be thinking when we move around states, when we move around the world. Those are the types of things to be thinking about. Something as simple as a lit hole can really get you into trouble. So my message today is, because you're in-house counsel, that does not insulate you in any way from the ethical rules. And a lot of these ethical rules weren't drafted with you in mind, okay? But we have to be very cognizant of these rules, and we have to see how they relate to us. And like I said at the very beginning, there's not a cookie cutter playbook for these things. Have someone you trust, whether it's in your own organization or outside counsel. I mean, I serve as a sounding board for my clients all the time to go through these ethical issues and to help them. And so there's lots of other issues. These are 10 that I particularly liked. So as I said at the beginning, I hope I've told you something you didn't know about the ethics obligations that you have. And hopefully it wasn't like watching paint dry. So thank you so much for having me. And Rudy, I'll be glad to take questions. And as I said, if anybody needs any of the extra handouts, they're right here. We have a question here.
I have a question regarding when in-house counsel is sitting side by side with a team of outside counsel and various issues arise, but you have your outside counsel who actually sits within the corporate to come to the company. And any special instructions for in-house counsel when you're moving from business to business and the business gets really familiar with your outside counsel and they're basically assumed into the business, right? Mm-hmm. For how we make sure that we're not crossing the lines and allowing more of the outside counsel helping make some of the business decisions and inadvertently waiving some of the privilege or some of those concerns when you have kind of a dual role when you're outside counsel.
Right. Well, dual role, whether you're in-house counsel or you're outside counsel, again, like you say, things start getting so chummy. We all know how this works, okay? You know, you love your outside counsel. Your outside counsel loves you. You're talking. You're working seamlessly together, and then maybe you're socializing with them, and it just becomes a little too chummy, and so. In terms of keeping those lines stark, right? Because they can be second guessed. You can be second guessed, and what's business advice, what's legal advice. And so, you know, I guess there's no hard and fast rules, but I think that keeping the legal stuff legal and doing some of the things that I talked about, right? Saying in response to your request for legal advice and, you know, that type of thing. I think that can go a long way toward doing that. And I think that you need to really be careful to mixing legal and business advice. We've all seen courts in discovery where, you know, the court takes it in camera to look at this stuff to say, is it legal advice? Is it business advice? And then, you know, the court says, well, this little part of it is legal advice, so we're going to redact that, and this is more business advice, so that's discoverable. It can be horrifying. It can be absolutely horrifying, because when you're reading about your opinion or whatever that's being discovered, and you're the one on the hot seat, it can be really ugly. So I don't know if that helps you. I'll be glad to talk with you afterwards to follow up. But anyway, no easy answers, unfortunately.
Hey, Jordan, we have a question online. I'm going to read it to you.
Yeah.
Regarding traveling across the borders with devices, the part about customs agent being able to demand your password is concerning. Are you suggesting that if an in-house attorney is traveling on personal international travel, i.e. vacation, that attorney not bring a device that she can access work email from?
Okay, well, I'll tell you, I can tell you my law firm's policy. I can tell you the ABA guidance. Okay, the ABA is all over this issue, okay? And Hillary Bass, who was my law partner, it all started coming up when she was president of the American Bar Association. This is when all this stuff came in. And I can tell you that the American Bar Association has very strong guidance. It doesn't matter if you're going on business, pleasure. When you're taking stuff across the border, I mean, you are taking a chance. You are taking a chance. It's not happening. I mean, maybe it hasn't happened to you, but you can see that there's so much activity here. ABA is concerned about it. They issued that guidance when there was a meeting in Vancouver, an ABA meeting in Vancouver. And they said, hey, y'all, well, they didn't say y'all, but they just said, hey, do not take your stuff with you. You know, they're serious about this stuff. So my message to you is there's legislation, there's guidance from the ABA, and it says, why are you taking this stuff with you? Leave it at home. Really? Why do that? If it's important stuff, if it's like the cross-border investigations on anti-money laundering, Foreign Corrupt Practices Act, take new stuff with you. You know, why do you need the keys to the kingdom and all of your clients' secrets on your little access device? Why are you taking that with you? And so, you know, my law firm has very strict policies on what we do and what we take with us. So it's just something to be mindful of, something to be very mindful of.
Thank you. Any other questions from the floor?
We have one over here.
Can we have a copy of the presentation materials?
I don't know. We'll have to, maybe you can ask Susan.
Okay.
She's the one I know best. I've known her, she and I have been in, you know, we've known each other for many years. So I would say that we'll have to ask the Association of Corporate Counsel if that's available. I sent it to them and obviously they put it up, so I don't know what their rules are. But I'll be glad to send them to you if you want to shoot me an email.
Any other questions?
Anything else? Rudy, how are we doing on time? Are we 2 minutes if we have any other questions?
All right, Jordan, any final thoughts?
No, I think that, you know, if you have questions, you know, I'm easy to find. And I really thank you so much for your participation and your patience. So thank you.